Welcome back, everyone. We will now start the lunchtime chat, the confluence of civil and common law influences in international arbitration. The panelists for this session are Mr. Chan Lung-sun, SC, Deputy Chairman of the SIAC Board of Directors, and Senior Counsel and Arbitrator at Essex Court Chambers, Duxton. Dr. Michael Moser, member of the SIAC Board of Directors and International Arbitrator at 20 Essex. Mr. Philip Jeyaretnam, SC, Global Vice Chair and ASEAN CEO at Dentons, Rodyk, and Davidson, LLP. Ms. Jeonghye, Sophie On, co-head of the International Dispute Resolution Team at Yulchon, LLC. Mr. Liyu Denning Jin, partner at the Han Kun Law Offices. And Ms. Chié Nakahara, partner at Nishimura and Asahi. The moderator for this panel is Ms. Adriana Uson, head of the Americas at SIAC. Ms. Uson, please.
Thank you, Michelle. Hi, everyone, and welcome to SIAC's first virtual Congress. I'm Adriana Uson, SIAC's head of Americas, and it is my pleasure to be your moderator for this session. It's a beautiful afternoon here in Singapore, and I hope everyone is healthy and well during these challenging times. So for today's lunchtime chat, we will be examining whether legal traditions, in this case, common law and civil law, have any impact on the practice of international arbitration. Some say that the common law-civil law divide causes conflict or imbalance in the proceedings, while others say that this has led to the emergence of an international arbitration culture which fused together elements from both legal traditions to bridge any divide. We are extremely fortunate to have a very esteemed panel from both common law and civil law backgrounds who will analyze this issue by going through the different aspects of the arbitration proceedings where practices might diverge. So let us start by finding out from Denning, who has qualified in China, whether there are defining differences between civil law and common law style of drafting written submissions. Denning?
Okay, thank you, Jeyaretnam. China is one representative country of civil law, but Chinese arbitration, has its own style. Compared to international arbitration, I think two most important elements of Chinese arbitration should be noted. The first one is the hearing will be conducted comparatively early, only after several months, after the case is filed with arbitration institution. The second is that in the Chinese practice of arbitration, the style is inquisitorial style rather than adversarial style. So taking into these two elements into consideration, I think the drafting style or written submission have different functions compared to international. The timing and function are different compared to international arbitration. For example, because the hearing is early, maybe the respondent has no time to submit very detailed written defense. Sometimes they will submit a very brief defense before the hearing. But the detailed submission of defense may be submitted after the hearing. But as to the claimant, I think the claimant will have to submit a comparatively detailed submission before the hearing, because you have to let the tribunal know what your case is. So the application for arbitration in Chinese arbitration have different functions compared to the notice of arbitration in international arbitration. You have to contain certain details of your case. The other elements is inquisitorial style of adjudication of the case. So the parties will have more focus in their written submission on the legal issues summarized by the tribunal. Sometimes the tribunal will summarize these issues. They will call these issues in dispute. In my mind, I think this is a sort of roadmap, to finally decide on the claims or counterclaims or the defenses. So the written submission, the drafting style and level of detail will be corresponding to the questions or the focuses raised by the tribunal. Other things, I think, the submission of law in China, we have different kinds of sources of laws. Statutory law is the most important thing. In nowadays, I think judicial decisions are commonly referenced in many cases if the statute is not so clear. And also, we have some deeply rooted in the mindset of Chinese legal practitioners notion of law, sometimes issued by the Supreme Court of China. For example, recently, we have a minutes of the 9th National Courts Conference on Civil and Commercial Adjudication. I think the international practitioners or councils, you have to pay attention to these sort of things, issued by the Supreme Court of China. I think, compared to international arbitration style of written submission, in most situations, these submissions are covering all the issues, maybe not summarized by the tribunal. I mean, the hearing will be very late. Before the hearing, the parties don't know exactly, what are the focused issues. So you have to include all the issues in your written submission. But I think, the efficiency, contained, reflected by the Chinese practice can be sometime, taken as a reference to improve, to harmonize, the international arbitration. Yeah, these are the points I would like to make initially. Thank you.
Are any of our panelists, would you like to share anything or add to what Denning just said? Well, thank you very much, Denning. Now let's do document discovery. I would like to ask Michael, who has served as an arbitrator in more than 300 cases in Asia, Europe, and North America, whether based on his experience, there is a difference in the civil law approach versus the common law approach in the area of document production.
Voila. Thank you very much, Adriana, and good afternoon, ladies and gentlemen. I think document production in many ways is sort of like the poster child for the debate between common law and civil law. It's an area where the line between the two traditions really is very starkly drawn. But it's also an area where more efforts, I think, have been made to try to bridge the gap between the two traditions. So let me try to talk a bit more about those 2 points. First of all, about the differences. I mean, for common law lawyers, justice as a starting point really can only be served if both parties have access as far as possible to the same materials. That's the idea. So a party mustn't only produce documents that it intends to rely on, but it also has to produce those things which may have an adverse impact on its case. And you have this whole broad range of devices like orders to produce documents and interrogatories and depositions and so on and so forth. Now, this idea is diametrically opposed to what we would find in most civil law jurisdictions, because there the whole idea, even the word discovery, is enough to inject fear into the hearts of a civil lawyer. Because in civil law jurisdictions, it's the judge that has the primary responsibility to inquire into the facts of a case with the assistance of the parties. And the parties would only present documents that they wish to rely upon. They don't have an obligation, in most cases, to present anything that would damage their own case. The mentality is totally different. A civil lawyer would say in a common law court, hold on, you're suing me. So why should I be forced to provide you, my opponent, with all of these documents which you need to prove your case. And fishing expeditions, we often think of as kind of an Anglo-American concept of common law, in fact, is a word that arises out of a court case in Germany from 1892, when the German Supreme Court used the term fishing expeditions to prevent what it saw as an inappropriate request for a document by a party. So now, while these differences between the two systems can be overblown, they are, however, real in practice. Now, what has international arbitration done to try to strike the balance between the two systems? And I would say a lot. Most importantly, it's developed this new language, kind of this Esperanto for international document production, which we find in the IBA rules. And here, as a result of this very fruitful collaboration between 17 common and civil law lawyers, a system of compromise was put into place whereby parties would be able to request documents which were identifiable, which fell into narrow and specific categories of request, which would be relevant and material to the outcome, and so on and so forth. So you have a much more carved back, honed down system of document requests. And the impact, I would suggest, in my experience, has really been quite profound on international arbitration practice. Now, has it been perfect? Of course it hasn't. The IBA rules are not to everyone's liking. US parties, for example, frequently complain that the IBA procedure is a toothless one. I mean, how can you request documents if you don't even know whether they exist? And how can you describe with particularity documents which you've never seen before? So for US lawyers, it's often antithetical. But criticism also comes, we have to remember, from civil law practitioners. We see this, I think, quite clearly in the Prague rules of 2018. There we had a group of civil lawyers who drafted these Prague rules. In fact, the original document produced in the drafting sessions prohibited any form of document production at all. And it was only subsequently that in Rule 4, a procedure for production of documents on a very limited basis was reintroduced. Now, my own view on this is I think we have to be very careful that we don't throw the baby out with the bathwater. I think that the IBA rules, in fact, have provided a very, very useful compromise position between common and civil law approaches, reflective of the special needs of international arbitration. But at the same time, that compromise, in my view, can't be held hostage to either tradition. And here I would note, I think, with some dismay, recent trends we see in our part of the world in respect of document production becoming increasingly contentious and formalistic, demanding, and prolonged. And I think we need to step back a bit and ask ourselves, does this really suit the process? Is it fit for purpose? I think we need to be vigilant that we don't create again a new chasm between common law and civil law, where we have already more or less solved the problem. So I'll stop there and look forward to any thoughts that any of you may have. Thank you.
Thank you, Michael. I think that's a very interesting observation. At this juncture, I would like to remind the panelists, feel free to interject at any time after a panelist has spoken. So Now let's move on to witness evidence. I wanted to ask Chié, who is qualified and has practiced both in Japan and New York, on whether, in her view, the two legal traditions differ in terms of how the testimony of a witness is presented and on the weight it is given. Chié?
Thank you, Adriana. Hello, everyone. So the differences in civil law and common law legal systems in the area of witness evidence. So generally and conceptually speaking, in the common law tradition, the testimony is presented through live oral testimony of witness rather than in written form. Witness testimony is the crucial evidence and huge weight is given to the examination and cross-examination of the witness. That is said to be a consequence of the preference for oral proceedings and the jury deciding on the facts of the case on the basis of what they heard from the witnesses and counsel's oral submissions. Under the common law tradition, the questioning of witnesses conducted by counsel, with each party having the right to have their counsel cross-examine the witnesses directly in the presence of the finder of the fact. In contrast, in civil law systems, where I am initially trained, the background is said to be a great mistrust or great mistrust of witness testimony, and greater weight is given to the documentary evidence. And the professional judge could or should hardly be influenced by the aggressive tactics of counsel or the emotional testimony of the witnesses, which may be effective in the case of the jury. So the civil law believes that the best evidence comes from documents because people lie and act. While witness testimony can be crucial to a case, the civil law generally gives far less weight to live testimony than the common law and treats the testimony of witness with considerable skepticism. Remember, I said witnesses lie and act. So accordingly, in the civil law tradition, evidence and testimony generally is presented principally in written form. While live testimony may be taken, the questioning of witness is conducted not by counsel, but rather by the court. And the judges have the sole authority to determine which questions are to be presented to the witness. If this tradition goes to the extreme, direct adversarial cross-examination of witnesses by the counsel is not permitted. In such case, the role of the lawyers for the parties in the civil law tradition, they can generally be limited, that role can be generally be limited to suggesting to the judge questions that should be asked. So the two traditions differ not only in how the testimony of the witness is presented, but in the weight it is given and how such testimony is tested. And let's think about it. Is there any harmonized or internationally accepted procedure in international arbitration? The current standard practice in international arbitral proceedings seeks to strike a balance between the common law and civil law traditions. However, I must point out that the current balance tips a bit in favor for the common law model. In the context of international arbitration proceedings, written witness statements are the standard way of presenting the evidence, with the written witness statement taking the place of direct examination. However, the content of such witness statements differ case by case. In some cases, the witness statements serve as a complete substitute for the direct testimony, and the hearing commences with cross-examination conducted by opposing counsel. Well, this practice has the advantage of shortening the hearing and helps to eliminate the surprises. In other cases, the written witness statements provide only a general overview of the testimony, with the witnesses able to supplement their testimony with direct examination by counsel at the hearing. In any event, in either case, heavy use of written evidence in international arbitration reflects the influence of civil law tradition. Also, it is generally well established in international arbitration that any witness presented by a party must be made available to testify live before the tribunal, with the opportunity for opposing party to cross-examine the witness. The procedure is outlined in the IVA rules and the presentation of live witness testimony and the concept of adversarial cross-examination of opposing witness is drawn from the common law approach. Also, most tribunals allow counsel to question witness first before they ask their questions. So it can be said that there exists standard international arbitration practice to a certain extent with the basic framework I just introduced and explained. That being said, regarding the style of examination of the witnesses, I must point out that certain cultural differences still remain to a certain extent. Well, I have witnessed several times that a common lawyer trying to crush the credibility of witness by a very energetic and fierce cross-examination. And it seemed that his efforts just led the civil law arbitrator sympathizing with the suffering of a witness. And I say from the civil lawyer's point of view, that witness's testimony would otherwise have been discounted due to the fact that it was uncorroborated by a document. Also, I must point out there are some challenges that the cross-examination in international arbitration that derives from the arbitration being the crossroads of common law tradition and also the civil law tradition. The oral depositions and the document discovery are the essential tools that U.S. counsel typically rely on to conduct and control their cross-examination. So it is obvious that cautious steps are to be taken by counsel, conducting the sort of the blind or to the jumping into the darkness type of cross-examination that inevitably occur in international arbitration without those tools, where counsel often have little assurance of knowing what a witness will say during the course of a cross-examination. In any event, parties to international arbitration proceedings, whether from common law or civil law traditions, can be relatively certain that written witness statements will have to be prepared and that their own witnesses will be cross-examined and they may cross-examine the other party's witnesses. To that extent, I think that we can say that the transnational standard has been developed. Unlike the rules of litigations, the rules that govern international arbitration depend on the choices of the counsel and the tribunal. So the challenge of international arbitration, advocating at the crossroads of the common law tradition and also the civil law traditions, ultimately produces the opportunity for each counsel in each case to tailor-make the procedural rules that best suit such specific proceedings and that best suits and serve the party's needs. So I must say, regardless of where we have been trained, the counsel shall be open to the advantages offered by the procedural models of other legal systems. Thank you.
Thank you, Chié. Chié, I wanted to ask, have you experienced any challenges as a civil law lawyer in the adversarial cross-examination of the witness?
The answer is no. One, because I am dual qualified and also trained in the common law country as well as many other international arbitration practitioners are. Two, as a practicing lawyer in Japan, I have to tell you that how witness evidence is handled in Japanese courts are quite similar to that of international arbitration. We don't have the oral depositions or the broad scope of document discovery. So the challenges we face in our in our courtrooms, the blind cross, jumping into the darkness type of cross, is so similar to the ones that we face in international arbitrations.
Thank you, Chié. Any intervention from our other panelists on the topic of witness evidence? No? Okay. So I would now like to ask Sophie, who is qualified in Korea, whether there are any differences in civil law and common law approach in the area of expert witness evidence.
Thank you, Adriana. Hello, good afternoon, my friends and colleagues. Well, there are differences between civil law system and common law system, of course, about the expert witness role. In civil law systems, particularly focusing on Korean system, experts are appointed by the court. So if the parties believe that the experts are necessary, then they have to request the court to appoint an expert. To the contrary, the court can always appoint an expert on its own discretion or per the request of the parties. So in principle, the expert should be a natural person who has no conflict of interest with either party. And it is the court that pays the expert fees and expenses. And the amount of fees and expenses are very nominal because it's determined by the Supreme Court's regulation. So the expert's motivation is not monetary. They cooperate the court because they consider it kind of honorable. So the experts give testimony before the court under oath. Well, but in a civil law system, in common law systems, well, as far as I understand, usually the experts are hired and paid by the parties to evaluate the fact or an action. And in some systems, the court can also call upon experts, even if the parties have already appointed experts. And the expert is supposed to serve as an objective party, but in many cases, in practice, experts are used by both sides to advocate their different positions. And it is left up to a jury or judge to decide which expert witness to believe. And from my experience, the expert witness system in international arbitrations are kind of harmonized system, but they seem to be more similar to that of common law system rather than civil law system, because they are hired by the parties. And theoretically, they serve as objective parties, but in reality, their testimonies are almost always in favor of the parties who hired them. And considering that the expert fees are very expensive, it is not surprising that they become kind of hired guns rather than play a role of a neutral and independent party. I do not believe that there is an ideal system or something like that, or I do not believe that we have to drastically or fundamentally change the current system, but it will be worth trying a different style, adopting a little bit more elements from civil law systems. In my view, the major reason that the expert witnesses are in favor of the specific party is that they are hired and paid by the party. So if the tribunal appoints an expert witness and each party pays half of the expert's fees, as they do for the arbitrators, then the expert witness can be a more real objective party because they are free from the party's pressure. And the parties can save the cost if the tribunal appoints only one expert. It will benefit the parties, especially in an arbitration case of relatively small size. And of course, I admit that there are some weaknesses in the system I suggested. Above all, the parties cannot control the risk that the only expert witness is biased. To supplement this weakness, of course, the tribunal will be very careful in appointing an expert and consult with the parties before appointing the expert. Also, we may consider applying IBA guidelines on conflicts of interest in international arbitration to the expert or potential expert. And we will have to make it clear that the tribunal will consider the expert witnesses' report or testimony for their information or just for reference. And the tribunal will not be bound by the expert's opinion. Or we may consider that the tribunal appoints more than one expert, but not too many, for example, 2 or 3, depending on the size or the complexity of the dispute. Of course, we cannot completely remove the risk, but I believe that the risk will be nominal and we can take it, particularly considering that we take the same or more risk when we appoint the arbitrators. So although we already have a harmonized system in international arbitration, we do not have to avoid adopting another harmonized system because different options can benefit the parties. Thank you.
Thank you, Sophie. Sophie, I'd like to ask, what do you think should be the appropriate scope of documents to provide for the expert?
Thank you for the good question. Well, the simplest way is just to keep them all the pleadings, all the exhibits and witness evidence submitted to the tribunal until then. But well, this can be adopted in many arbitrations. However, in some cases, this can force the experts to play the role of another arbitrator. So to avoid such a risk, maybe we can consider providing them with undisputed facts only. But in the event that the undisputed facts are so insufficient for the expert to evaluate the case, then maybe we can allow the expert to request for more documents which are relevant and material and not too broad. And then the tribunal determines whether the requested document will be provided or not, of course, after consulting with the parties. And I think it will help avoid the risk.
Thank you, Sophie. So having now talked about written submissions, document production, witness and expert evidence, let's now move on to the tribunal's role in the arbitration proceedings, especially at a hearing. I would like to put this topic to SIC's Deputy Chairman and Senior Counsel in Singapore, Leng. So to Leng, to what extent do you think should a tribunal intervene in an arbitration? Is arbitration necessarily adversarial in nature, or can the tribunal take a more inquisitorial approach?
Thank you, Adriana. Well, I have to say that I'm speaking from my personal capacity, and I'm free to change my mind later. Well, I will focus just on one topic given the time limitation, and that is the extent to which the tribunal should and can intervene in an arbitration. And here we've been talking about the adversarial system, which basically leaves it to counsel for both parties to determine how they want to present the case, what evidence they want to present, and what issues they want to highlight as important. Whereas in the inquisitorial system, the tribunal takes a more proactive role and may give certain directions on what the tribunal wants to see or hear. But ultimately, my submission is this, and that is whether the tribunal or counsel comes from a civil law or common law tradition, there is a danger in excessive tribunal intervention in a case because it can lead to a challenge of the tribunal or the award on a couple of grounds. First, that the tribunal might appear to be biased for straying into the arena and taking the role of one party. Or secondly, that there has been an unfair process because the tribunal has intervened so much that it has impeded one party's ability to present its case. Now, of course, we all accept that whether it is an adversarial or inquisitorial system, the tribunal does have the power to proactively manage the arbitration. And in fact, the tribunal should do so to minimize time and cost. We have heard the Chief Justice speak today about the main concerns of parties over a number of matters that are not so positive about arbitration. Among them would be rising cost and to some extent delay. So it is actually increasingly common for tribunal to be more proactive in managing the arbitration. And you find this, for example, in Rule 19.1 of the SIAC rules. So it is okay for the tribunal to seek clarifications early on from parties as to their case so that the tribunal understands what the issues are and how to then manage the arbitration so that the issues can be addressed. But there are a few things that the tribunal should avoid. One is that the tribunal should not act like an expert in an expert determination. There is a kind of dispute resolution, we all know, which is called expert determination, where parties just chose an expert to make a finding, usually on a technical issue. Now, tribunal and arbitrators may think that they know everything, and sometimes they are chosen because of their expertise in a certain area. But it's extremely important that an arbitrator does not stray into the role of an expert in expert determination. This is because an expert can rely on his personal expertise and make his own inquiries without any obligation to seek the parties' views. And he's not obliged to make a decision on the basis of the evidence presented to him. This is something that an arbitrator cannot do. The arbitrator must base his decision on what is presented to him by the parties. There are two other areas of concern which have been highlighted by the Singapore courts. Although they take part, these concerns were expressed in litigation, I feel that they are equally applicable to arbitration. And this would be whether you are arbitrating under common law or civil law sensibilities. The first is that you should not prejudge a case. And by prejudging a case, I mean that the tribunal may sometimes feel tempted to express views very early on about the case. Now, we as counsel have often seen that what is supposed to be a tentative view often turns out to be the final view. And if the tribunal expresses a view too early, there's a danger that is perceived to be approaching the case with a closed mind, right? And therefore, you are not really impartial in that sense. Your mind is closed, you're already biased against one party. The other danger is intervening excessively in the examination of witnesses or even in telling counsel what to do about the case. There have been cases in Singapore in courts where a judge was challenged because the judge asked too many questions of the witnesses. And the danger of asking too many questions is that you might be impeding one party's ability to present its case according to how it sees fit. And you could be interfering with a counsel's right to examine a witness in the counsel's own way. Now, it doesn't mean, of course, the tribunal should not intervene. The tribunal can intervene and should intervene to seek clarifications. So it is a matter of degree. And I will end here with just a quick reference to the Prague rules that I think Michael referred to just now. But by and large, the Prague rules are fine insofar as they encourage efficient and proactive management. But there are a couple of provisions in there that we have to be a bit careful about, in my view. And that is in Rule 2.4, it says that the tribunal may indicate to the parties with regard to the disputed facts the types of evidence the tribunal would consider to be appropriate to prove the parties' respective positions. I would urge tribunals to be a bit more circumspect about expressing that kind of view or that kind of advice early on, because you might be seen to be assisting one party, that's one. Or if you express a view too early on how the case might be proven, you might find later at the hearing that you are wrong because you didn't appreciate certain facts. And then it is a little awkward for the tribunal, having guided one party on what evidence to bring, to find that, oh, maybe that evidence is not enough or is irrelevant. And finally, there's a provision on expressing preliminary views early on. I think, again, for the reason I have mentioned, the tribunal should be a bit careful about that. Thank you, Adriana.
Thank you, Leng. So now coming to, I would say, one of the thorniest topics, which is counsel conduct in international arbitration. I would like to ask Philip, one of Singapore's senior counsel, to provide his perspectives based on his experience as both counsel and arbitrator on the different and sometimes conflicting standards of counsel conduct in international arbitration. Philip?
Sure, thank you, Adriana. I think it's right that my topic comes at the end of these very interesting and detailed presentations of different aspects of procedure which differ between the civil law and the common law systems. And that's because really professional ethics itself is really a species of role morality. It's about what are the rules that we need to be governed by when we are playing a particular role in a particular system. And so naturally, the rules that we are governed by will change depending on the system that we are participating in. And I think to kind of recap a little bit of what has been said before, but just to draw it out into the ethical arena, The adversarial system necessarily emphasizes the parties' right to conduct their own cases and to present those. And that then in turn leads to this emphasis on the oral hearing, and the emphasis on the oral hearing and then in turn cross-examination is the way to get to the truth, and then supported by broad discovery obligations, but all of that mitigated by extensive witness preparation. And of course that differs from one common law jurisdiction to another as to how much witness preparation is allowed, but it is definitely a critical part of the system because it gives the side resisting cross-examination the shield, some degree of preparation for that battle. Whereas the inquisitorial system, the adjudicator is the one in charge of really looking into the facts. And that leads to, because of that perspective, they don't have the same knowledge of the facts as a counsel would have. There tends to then be this reliance on contemporaneous documents over oral evidence. How on earth does an adjudicator coming into it from above without the detailed knowledge of a counsel get to the truth through oral examination? Really quite difficult. But then in turn, no or limited witness preparation, because that would be seen as interfering with the adjudicator's ability to get to the truth. So that's where it comes from. And then when you turn to arbitration, I think as many of my earlier speakers and indeed in the earlier session have talked about, arbitration is, well, first of all, meant to be a flexible procedure. Chief Justice quoted Jan Paulsen, quintessence of bespoke justice. He counterposed that with something that Toby Landau had said about the solidification of expected procedure. And I guess really arbitration is somewhere in between those two characterizations. It is still a flexible procedure, but undoubtedly for two reasons, the adversarial system has kind of greater influence. One is simply, I guess, the role of Anglo-American law firms after the Second World War in international trade and investment. But secondly, this concept of right to be heard and denial, a denial of natural justice as a critical component, or giving of natural justice as a critical component, perhaps, that inevitably starts to fortify cross-examination or oral hearings, because if one party says documents only, another party says oral hearing, well, it's the party who's asking for more who's going to be able to complain of having been denied something. So the common law system kind of wins out in that sense, because the complaints would come if you're denied those additional weapons that the common law system emphasizes. Nonetheless, there's been this reduction in the role of general discovery, and there's been, I think people have talked about the IBA rules on the taking of evidence. So to that extent, I think on discovery of documents, there's been a great deal of convergence. And I think civil lawyers and common lawyers approaching an arbitration probably have a broad understanding that, yes, you certainly can't hide documents, but at the same time, unless you're asked for it, you don't have to volunteer documents, which is a sort of middle path between the civil law and the common law. I think the secret to it all, how to deal with things properly within an arbitration, is really if counsel are perhaps new to the game, then it's incumbent on the tribunal to make sure that the possibly different assumptions of different counsel on both sides are brought out into the open and articulated so that the rule that everybody is going to follow is completely clear. To me, the one rule which remains sometimes unknown to civil lawyers, or perhaps maybe not, that's too much of a generalization, to some civil lawyers, would be the sequestration of witnesses during giving of evidence. That's sort of part of cross-examination as this great weapon for common lawyers. Witnesses are then not allowed to talk to anybody while they're being cross-examined. I think it's very important that a tribunal decide whether that is indeed the rule that is going to be applied, and make sure everybody knows it, because there are people from some countries who wouldn't understand that, and there's no reason. It's not a great grand ethical rule. It's not like stealing or murder or lying. It is simply a question of role morality. So the tribunal must, I think, be very clear about things like that. What is the degree of contact allowed with witnesses? So I think that's my introduction to things. There are definitely quite a lot of differences between the two systems, many of which have been worked out over time. And I actually don't think there's a great deal of difficulty in what remains. Quite optimistic that in most arbitrations things go very smoothly in terms of people's understanding of their roles and their ethical duties.
Thank you for that, Philip. So we're almost close to the end of our session, and I just want to ask the panelists to tie it all together, to give us a brief answer to the question we posed at the start of this session, that is whether legal traditions, common law and civil law, have any impact on the practice of international arbitration. So who wants to go first? Should we start?
Can I start with that?
Oh, sure.
Michael, you want to start?
Sorry.
All right. Maybe I kicked off that topic because I wanted to follow up on what Chié and Sophie said about testimony. Certainly, arbitration is a hybrid of traditions, although we have heard that the adversarial or common law system tends to have a bigger influence in international arbitration. I think that is correct, which is why civil law lawyers have got to adapt to this idea of an oral hearing with cross-examination of witnesses. But certainly you do see civil law influence permeating arbitration. I think that's a good thing. For example, what they spoke about in relation to witness testimony. I think even civil common law judges are becoming alive to the fact that memory is a very unreliable thing, right? So we have to rely more on documents to reconstruct events, and witnesses who can be totally honest can still be under an illusion or be tricked by their brains as to what actually happened, with the power of suggestion from counsel and so on. So that's one thing that arbitrators are alive to. And secondly, lengthy cross-examinations is really not necessary. That's one thing we have found out in arbitration. So common law lawyers who think that they need to uncover every little point and test the witness for a day or two just on credibility, we'll find that that's really not a very productive way to go about the hearing. With regard to expert witnesses, even courts are also beginning to look more and more into the question whether the expert witnesses should, as a default rule, be with experts appointed by the court rather than by parties. Certainly, this is one question that's been addressed right now in discussions regarding the reform of procedural rules in court, although that has not happened yet. But where common law lawyers are concerned, there's always a little bit of wariness about giving up control, and that if you just let an expert witness who could be a wild card be appointed without your right to call your own expert, basically your case is, the fate of your case is in the hands of this unknown expert. Thank you.
Thank you, Leng. Who wants to go next?
Adriana, this is Michael. I just wanted to perhaps make an observation and then maybe leave a question. And the observation would be this. I mean, as we all know, human behavior is constantly changing and being shaped and reshaped in different directions. And I think if we look at international arbitration practice, particularly here in Asia, it's very interesting how our part of the world, and just looking at the composition of our panel here today, a good number of civil lawyers from civil law jurisdictions and common lawyers. And I think there's no doubt that probably the dominant force so far in terms of our little world of business as arbitration practitioners has been predominantly influenced by common law tradition. That has a lot to do with the fact that places like Singapore, Hong Kong, common law jurisdictions have a lot of arbitration activity. They're international business centers, and hence they absorbed those common law influences more readily. But the world, as we all know, is changing, and our behavior may change as well. So as we see more and more civil law firms and civil lawyers, people of civil law background, companies coming from major civil law jurisdictions, we can already see, of course, China, Korea, Japan. Many of the assumptions we have today about what's proper behavior and to what extent arbitrators, for example, can intervene, to what extent experts should be appointed by tribunals, and what they should be instructed, what materials, and all the questions we've been discussing today. All of those types of behaviors might change quite radically if we go off 10 years from now. So I think Adriana will have to come back then and revisit the issue at that time. Thank you.
Thank you, Michael. Who's up next? Philip?
Oh, sure. Okay, but I noticed the three common lawyers are starting off. I was actually going to hold back and get on the civil lawyers first. But I think, you know, clearly I think when it comes to efficient discovery, it's very clearly something where there, not just a middle ground, but perhaps a definite kind of beneficial influence from the civil law, together with, I think, the emphasis on contemporaneous documents as being very important for the outline and the bare bones of a case. But at the same time, I mean, myself as an advocate in the common law tradition and one who spends a lot of my life cross-examining, I do have to give a little shout out for that, especially after hearing what Leng San had to say, although hopefully all he meant was, you know, keep it shorter. And I think that's a fair point. I think you don't need a long time to cross-examine effectively. But for myself, if I'm acting for an underdog, for a client who's perhaps had the harder time of it during a project or action, is the one with less deep pockets. Cross-examination is actually the time when you turn the tables, and it really is the time when you can get at what the underlying truths and story are. And that's another reason why I absolutely agree with Leng San that tribunals who give preliminary views to Yulchon, it's not just that will be open to criticism in a court challenge, but also I think it's just bad practice, because the reality is the tribunal is only getting a very superficial view of a dispute at an early stage and really not be in a position to give incisive comments. Comments about the shape of the dispute, yes, the issues that might be important, but not about the merits.
Thank you, Philip. Chié. Oh, sorry, Danny.
I will make some comments as a civil law lawyer. I think we will see more, you know, harmonization, you know, of international arbitration. Take China, for example. I think more and more international arbitrators are coming to China to conduct arbitration, and the rules of Chinese institutions will allow, you know, will support, you know, the way for international arbitrators to conduct in their style of arbitration in China. And from the other side, I think, you know, there will be possibility that international arbitration institutions will conduct a hearing in China, or even take China as a seat for the arbitration conducted by the international arbitration institutions. You know, maybe we know the recent case decided by the Shanghai court, you know, SIAC, arbitration with seat in Shanghai. So from that end, I will see the opponent, trend that international arbitration will be counted in China. Maybe more Chinese aspects will be added into that style. So I think, as to Chinese arbitration, we will have a chance of internationalization of Chinese arbitration, and we will see more hybrid situation. So for the interest of clients, I think we need to, for every different cases, in different ways, we need to form a dream team, combination of civil law lawyer and common law lawyer to serve the client's interests. Thank you.
Thank you, Leng.
So should I go now?
Yeah.
Sure. I think Michael touched upon the thing about the proper behavior of the people, practitioners and the parties and counsel. And even though I would go back to the question, is there a real divide between the common law lawyer and civil law lawyer? Even though I introduced the general concepts of civil law and common law divide in my earlier presentation, I don't really see the real divide, at least in the international arbitration. In my experience, the actual differences in the area of at least in witness evidence come from the arbitrators and counsel's styles, preferences, and personalities rather than legal background. I have experienced English arbitrators leading, or shall I say, taking over the questioning of the witnesses in place of the party's counsel, and also witnessed that the German arbitrators, for example, have been content to allow the parties to start with the questioning of the witnesses many times. So I would say it is a distinction without a real difference in approaches, or flavor without a real difference. Then if we talk about more harmonization, or what we can do as a civil law trained lawyer to make the arbitration process shorter or more efficient, I think about it, and I think about one good standard procedure. If that can be established, that would be ideal. But I would say that it is unlikely that the common law and civil law approaches to advocacy will ever fuse into a single set of absolute standard procedures for international arbitration. I mean, the proper behavior should be sought after. However, there won't be any one absolute proper behavior that fits all, cases. And I don't believe that they should either. So one of the great characteristics of arbitration, it was mentioned earlier several times, is the procedural flexibility. So with that, the process can be tailored to the needs of each case. And I believe if any confluence is to be seen, it is probably an acceptance of the certain range of procedural options available that are unlikely to be challenged from each side. Thank you.
Thank you, Chié. And now let's hear from Sophie.
Thank you, Adriana. Well, as Michael and Philip pointed that as a civil law lawyer, we feel that international arbitration are more like common law system court litigation rather than civil law system litigation. But I am not saying that I hate the system or I have to change the system, but and as Chié said, there's no absolute proper behavior, and it's particularly up to the personality or the preference of the parties, counsel or the arbitrator. And I absolutely agree that. And in Korea, there are many cases that the parties do not retain the counsel, or the counsel have very little experience or knowledge about the international arbitration, because the arbitration market grows very fast. And at that time, it is sometimes impossible to proceed with the adversarial system, because, in that case, the arbitrator should play more active role. So in that case, the procedure becomes more and more like inquisitorial system. So sometimes our behavior is up to the experience or knowledge of the counsel or the participants. And well, and basically as a civil law lawyer, I think there are more elements we can adapt to the international arbitration system to improve it from the civil law systems. And for example, in the international arbitration, cross-examination is very critical and crucial. But as I'm not sure, is it Jeyaretnam or Danny who said about that? But the witnesses' memory is not very reliable. So I think we can more rely on their statement, written statement. And I'm not sure whether it means a lot that counsel just crash the poor witnesses using the witnesses non-experience or poor knowledge about the procedure or the arbitration. And sometimes the witnesses are crashed because he or she told a lie in witness statements. But sometimes I witnessed that the witness was crashed because the counsel is very clever and more experienced.
Mm-hmm.
So in that case, I think, well, just denying or rebutting by the written statements to rebut the written statement is, well, kind of more efficient and reasonable way. So I think that's another element we can adopt or consider adopting. Thank you.
Thank you, Sophie.
Adriana,
Yes,
do
Leng.
you have time for 30 seconds? I'll just reply to that last point.
Sure.
Lest I'm taken to have said the wrong thing or being a traitor to my own kind. And that is, I'm not saying cross-examination is not necessary. I think hearings should be shorter and lengthy cross-examination is not necessary. And that's what Philip said as well. Because I have seen cases as well where the arbitrators actually told us at the end of the hearing that, oh, our impression of the case based on the witness statements. And when we came to the hearing, it was quite different. And after cross-examination, we have a different impression. So I won't say it's not necessary, but you need to be very focused. And I agree with Sophie that sometimes all these tricks about breaking down the witness and so on, we need to have a little bit more restraint on that. But by and large, the role of counsel as the detective cannot be underrated. Okay.
Thank you.
Yeah, I agree.
So we have time for some questions. I have a few questions here that I. So one question is, do you think that in addition to a certain separation between the civil law and the common law, that virtual hearings brought about from COVID-19 will result in a relook or reduction of discovery in arbitration? So anyone would like to take on that question? Yes, Leng.
I have spoken a lot, but Philip, do you want to speak?
No, I'm happy, Leng-san, for you to take that on. I don't think I have a strong view on that particular question.
I'm not sure I understand the question.
Yeah.
Adriana, could you perhaps say it again?
Okay, I'll read it again. So do you think that in addition to a certain harmonization between the civil law and common law, that virtual hearings brought about from COVID-19 will result in a relook or reduction of discovery in arbitration? So because of COVID-19, you think there's a change in process in terms of document discovery?
Right. Well, 2 quick points. I don't think it will result in any change to document production because that happens whether you're having a physical hearing or a virtual hearing.
Mm-hmm.
But it may result in shorter and more focused hearings, the conduct of the hearings.
Yeah.
Absolutely.
And
I agree.
I would also agree 100%. I think that where we are already seeing the difference, I think, is in a more disciplined approach to
Yeah.
cross-examination. Sorts of things that Philip and Leng were speaking about earlier. And part of it is simply the exhaustion factor.
Yeah.
If you take a 4-hour hearing via Zoom, intensively cross-examining witnesses, I think it takes an awful lot more out of counsel and the tribunal, not to mention the poor witness, than it does a live procedure. So I think this causes all of the participants to be much more focused in the process.
Yes, I totally agree. With shorter hours and with shorter days of virtual hearings that we can bear, I think the councils are encouraged to limit the scope of examination for the more qualitative and efficient process, where they should be agree not to cross-examine or inflate the evidence regarding the undisputed facts.
Thank you. So there's another question here. So the question is, how important is it to select an arbitrator from a civil law or common law jurisdiction? And what about when selecting external counsel? So if a party is from a civil law jurisdiction, does he need counsel from a civil law jurisdiction to help him advocate for a more civil law procedure? Any takers for that question?
Gosh, okay, maybe I can have a stab. I think obviously selection of counsel and selection of arbitrator are two of the most important decisions for a party when it comes to any arbitration. And I think it is something that one needs to think through carefully with all of the factors. Where is the seat? What is the governing law of the dispute? What is the type of the dispute? I certainly don't think you need to match a civil lawyer with a civil law seat or a common lawyer with a common law seat, or necessarily have a counsel who is trained in the governing law of that particular contract. I think we've reached a stage where we can have teams made up of a few people, one of whom may be au fait with the governing law, one of whom may be au fait with the law of the seat, someone else who is specialized in disputes. And as far as the arbitrator is concerned, I mean, I think we all know there are numerous wonderfully distinguished and experienced arbitrators, as well as some very good, capable, young, up-and-coming arbitrators in both traditions. So I think it's more look at the dispute itself rather than some general advice or proposition.
Thank you, Philip. Any others who would like to?
I think it will depend on the budget of the clients. But the key is you have to the key is that you have to have the lawyers, counsels representing you who know what the arbitrators in that place of arbitration think about your case. The way of the culture, or the way of application of law, the way of conducting the arbitration, how to present your case, your facts to these arbitrators. You have to have a lawyer who really know that. It means maybe a local lawyer should be used. For example, in the arbitration cases conducted in HKIC, I would normally advise our client to join a barrister, Hong Kong barrister, or even QC from London, or common law lawyer, to co-counsel with us. Yeah.
Thank you, Denning. So I have another question here. If party autonomy is the cornerstone of arbitration, should seeking harmonization or confluence of common and civil law influences be the goal?
May I?
Yes,
I
please.
do not think that the convergence of the civil law and common law can be a goal, but it can serve as a method to seek the party autonomy, because the party autonomy can improve if we have more and more options. And in these days, our option is quite limited to something more similar to common law. So if we have another option, which is a little bit similar or more harmonized, more similar to civil law, then we will have more options, and I think it will help to improve the party autonomy.
Thank you, Sophie. So another question from our attendee. Do you feel the Prague rules facilitate a reasonable trade-off between efficiency and procedural protections? So I know we've discussed IBA rules and earlier, but this time, like, what do you think about the Prague rules?
Maybe we should let the civil law lawyers have their say, since I have already expressed some views on some provisions of them.
Well, let me just start on that and then see if any others can join in. I mean, I think, like everything else, the Prague rules have some good points and some drawbacks. But I think the most important thing in this exercise, when we talk about the division or the gap between the two systems, or we talk about Prague rules versus, say, the sorts of key characteristics of an adversarial type procedure that Philip and Leng were addressing earlier. I think the important thing to keep in mind is we are in arbitration, and we're not kidnapped by either legal tradition. Last night, as we were, as I was thinking about today's session, trying to get my thoughts together, in fact, I was playing Lego with my two grandsons, and I thought to myself, well, this is really what it is. I mean, it's all about taking some building blocks from different aspects of the two systems, whether it be experts of the kind, Sophie, that sort of issue she was talking about, Chié was talking about conduct of proceedings with witnesses, and Denning also with submissions and so on. There are points that we can all take and pull them together to make something new, and we're free to do that. I think that what we saw in the Prague rules was a reaction to the increasingly aggressive position which has been taken by the major international law firms in arbitration that are largely dominated by common law practitioners in making international arbitration proceedings more and more like an English court proceeding or common law court proceeding. And I think that if you were to ask people who drafted the Prague rules, I think that was one of the motivating forces behind their thinking, was to put something new on the table, which really is in contradistinction to the way we have been moving under the common law influence. So to the extent that it provides us with more options to think about when we design procedural orders and timetables and thinking about ways of how to have our new hearing, it can only be a good thing.
Thank you, Michael. So I guess we have time for one last question. So this question is, SIAC has always taken great care to make sure that its rules and practices are accessible to both common law practitioners and civil law practitioners. Part of this is due to geography, as Singapore and Malaysia are two common law countries with many civil law neighbors. These efforts have worked out quite well for SIAC because year on year, SIAC's top 10 foreign users is almost an equal split between common law parties and civil law parties. So against all that background, what more can institutions be doing to provide a harmonized product so to speak, to both common law and civil law users. It's actually a survey from SIC.
I'll just say that the SIC rules are constantly being monitored and are constantly being reviewed. I think the trend, as people may have noticed, is that every few years we have a new set. But we have to bear in mind that institutional rules are just a rough framework. So when it comes down to some of the actual practices that we've been talking about, Prague rules being one example, IBA rules being another, these are much more detailed guidance notes on the conduct of an arbitration. And it's better that the actual practices be determined by the tribunal in consultation with the parties, rather than being prescribed in the institutional rules as a contractual set of rules, because we shouldn't be overly prescriptive, because the rules are not, they cannot be so flexible as to be changed every other day. And it must allow lawyers and tribunals, whether they are from civil law or common law tradition, to be able to operate within their own comfort zone under that same umbrella.
Thank you, Leng. So
I would fully endorse that.
thank you. Well, we have come to the end of our lunch chat. I think that was a rich and informative discussion. I hope you enjoyed it as much as I did. On behalf of SIC, I would like to thank our excellent panel for sharing their insights with us. I would also like to thank our viewers for tuning in. Please do stay on. The virtual debate will be coming right up after the break. Thank you again and have a great day ahead.